Hello guys, welcome to another epic family court case filled with drama, heartbreak, and more. Today's credit goes to court watchers. Don't to subscribe to my channel AI Reaction. Let's dive in.
Ms. Kelly's motion for modification of a parenting plan, child support, attorney fees, and the like, with some interesting issues. So we'll hear from Ms. Gilmore first as the moving party, and then Ms. Winkles.
Megan Gilmore on behalf of the respondent and moving party, namely Crystal Kelly. I would first like to memorialize my objection regarding the numerous materials filed on Friday and Monday of this week. I did present that objection to the court via email. I do apologize, that's relatively informal, but I didn't have any ability to get anything filed. So we are asking the court does not consider that for the purpose of this this motion today. Our original motion was filed in September. The court, if you do recall, set this over, I think, at least 3 weeks, so he had plenty of opportunity to respond. He filed under penalty of perjury a response on October 24th, and so those materials were, filed in violation of Local Court Rule 88. I'm also objecting to the consideration of the letter filed along with his responsive materials by Heather Hoke. We're just asking that that is not considered because it was not made under penalty of perjury, and she doesn't have personal knowledge to what was going on in my claims.
Well, let's go ahead and just address that, just those discrete issues. Ms. Winkles, do you have a position?
Yes, Your Honor. I came onto this case on October 16th. Prior to that, he was without counsel as his former counsel did withdraw at some point. That gave me a very limited amount of time in order to respond. In order to get the child's records, because really what we're talking about here is the best interest of the children or the child and how it impacts. Really, the best way we can do that is to have counseling records. Mom had some counseling records. Dad had no access. This is a child that's 13. We're on the child's timeline. If the child wants to give them, great. If the child doesn't want to give them, we wait. We waited till the child decided it was time to give them to the court. We've got them. They're with the court now. They're probably useful in determining whether or not this child's really been impacted. With regards to my client's supplemental declaration, there was new information presented in Mom's responsive pleadings. My client had no opportunity to respond to that. Additionally, my error, I did put that my client was on naltrexone. He obviously must have skimmed when he read it because he had typed it out first or handwritten it. And this is my fault. I had confused him with somebody else, a different client of mine. So he did want to clarify to the court, I'm not on this medication. That's a very small issue. His supplemental declaration is quite short. It just addresses a couple of new items that are new information that weren't in Mom's original. The medical records are the child's records. They're useful. They're necessary. Even though they're late, they are necessary. Mom had access to them already, so it's not prejudicial information that Mom is just seeing for the first time. This is Mom had them in her care and custody and cherry-picked which one she wanted. My client didn't have them. And again, we're on kids' time here because she's 13. So I'd ask the court to give whatever weight the court wants to give to them. But since we are looking at the child here, I'd ask that those records be used. My client's declaration is supplemental. It is small. It's small. It just clarifies a couple of things that were new in the other one. So thank you.
Thanks.
Sorry, I'm not objecting to the medical records. I have no objection to that. I'm just I'm objecting to the underlying declaration. It was 4 pages. My client, I don't believe, presented any new information within her biomaterials. They were all responsive to the allegations and frankly really pertaining to the allegation this was a final parenting plan. So I am asking the court not consider that declaration.
Great. Thank you. I think the children's medical records are key, so I am considering those. As far as the second declaration that was filed by Mr. Bamer on November 3rd, I'm not considering that. Ms. Hoke's information, I'm not considering that either. That's not under penalty of perjury, so I'm not considering that. Okay, with that, we'll hear from
Today's credit goes to our court watchers.
Yes, thank you. How far does the court want me to go into the procedural issue of the final order? Do you want me to move forward, or do you want me to get into the meat of that?
I spent a lot of time with this case yesterday. I think a brief review would be helpful to just kind of bring it back to memory. So
yeah, absolutely. I'm happy to do so. And again, Megan Gilmore on behalf of Crystal Kelly. This is before the court on my client's motion to modify particularly the temporary parenting plan. First, the parenting plan entered in April of 2022 is clearly a temporary order. And I'm frankly frustrated that my client must spend fees defending this claim given the clear reading of the order and intention of the parties that we've submitted within our reply materials. At the time my client was forced out of the community residence, petitioner with an attorney presented her a separation agreement. As detailed within her declaration, she signed the order without counsel and frankly what she believes under duress, as she had no funds to acquire her own housing and needed to have visitation with her daughter. However, no one, including my client or petitioner, believed that they were signing or entering final orders at that point. Even if we go beyond the extremely questionable nature of how this agreement was derived, the parties clearly again had no intention of making the parenting plan final, as this was not filed with the petition, but rather was filed in two separate filings of proposed parenting plan as well as a temporary order, which was memorialized with the court. Moreover, the order itself makes no reference to the fact that this is a final order, and at the time my client signed it, she was a pro se litigant. She had to rely on the face of the order and the communications between the parties. Beyond the fact that the face of the order makes no reference to the fact that it's final, there's no sort of subsequent orders that are required under statute, particularly findings of fact and other final orders, particularly relating and required with unmarried participants under RCW 26B020. You need to make what's required for the court to enter a final parenting plan pursuant to statute is making findings about, frankly, paternity in this case. These parties aren't married and that's required, even jurisdiction or child support. So this is further supported by the written evidence and the text messages between the parties. The parties were negotiating the terms and discussing going back and forth with petitioner's attorney on making said modifications. When the clerk's office provided notice of dismissal again because there was no understanding that this was finalized, petitioner's attorney filed a status report indicating that the parties were still negotiating the final orders. There's nothing to support petitioner's claim that the April 2022 parenting plan is final. We frankly believe he presents this allegation as a red herring to distract the court from the legitimate issues we believe are within his home. The court, again, clearly is what the information before the court is that this is a temporary parenting plan and nothing more. Furthermore, I present case law analysis that the court isn't bound by separation agreements and again is able to modify temporary orders upon a finding that the temporary parenting plan is no longer in the best interest of the child. So we do ask the court today make a finding this is a temporary order. Moving to the underlying merits of the motion, I already presented oral argument in support of our motion at the last hearing, so I'll make my arguments relatively brief and rely on the materials presented by my client. My client filed this motion as the child's mental health was severely declining in response to father's alcoholism and the conflict in his home that resulted in the child calling law enforcement. I'm frankly very concerned at the tone of father's responsive materials, as he's clearly isn't taking any accountability for his alcoholism and is willing to frankly make every excuse to avoid addressing the issue. The child's mental health records speak for themselves and truly show that this child is struggling during 50% of the time with her father. Following our hearing, father took it upon himself to inform this fragile 13-year-old child that my client presented the court, number one, with the mental health records and explained the information contained within those records. The child was threatening self-harm related to visitation with father. The child was absolutely devastated, and we believe that father presented this information to the child in an attempt to damage my client's relationship with the child. He then took it upon himself to change the child's mental health facility without any conversation with my client. We do acknowledge that the child's previous actual provider was going to another facility, or frankly, I don't know why she needed to no longer provide treatment, but my client was actively engaging in providing with another provider at the same facility. Father then again took it upon himself to make an appointment with a different facility with no notice to my client. He not only changed the facility, but then threatened the child with a subpoena when she refused to sign the release of information. My client is concerned by this. She was able to access the records previously prior to bringing this motion because the child wasn't 13 years old. But my client does believe that the child mental health provider needs to be someone that the child can rely on, and I am frankly concerned that we now have those records suggesting that those threats were made good upon, and he did force the child to sign those releases. I do appreciate the fact that it's needed for the motion and it's hard to balance that, but we don't believe it involving the child in conflict is appropriate. At my direction, my client requested a hair follicle test of petitioner to establish a baseline of father's drinking. The hair follicle shows long-term use. Father is in such denial that he's now trying to make claims that this test isn't legitimate or accurate without any sort of evidence proving that. Father then thought it was appropriate to send said drug test directly to the child in support of his threat that she must go to visitation with him when she was apprehensive. Father presented a declaration or penalty of perjury that he was taking a drug to help him with alcoholism. I'm confused how you state that that was made in error when it was signed by him under penalty of perjury weeks ago. Father similarly presents in his declaration that his last DUI was when he was 18 years old, but the records, the watch report very clearly show that the last conviction was from 2020. This motion was filed 6 weeks ago, and at this point we have no evaluation from Father. We have no proof that he started any sort of legitimate treatment, and we have a positive drug test for alcohol. Father asked the court to indicate that he's addressed his non-existent issue because he's done 2 online AA classes, which are frankly insufficient given the facts of this case. Beyond the alcoholism, I'm frankly shocked that number 1, Father admitted to telling this child to kill herself, and number 2, that he now under penalty of perjury tries to allege that's a joke. This is the same behavior that my client experienced during her long-term relationship with Father. Father becomes intoxicated on a daily basis. He hurts people verbally or physically, and then apologizes, claiming he'll stop drinking, only then to drink the next day or week. Father is in such denial that he admits in his own declaration that he doesn't need treatment, and unfortunately, I'm confident that it's not if, it's when Father will start drinking again to the detriment of this child. So we do ask the court to grant our motion and adopt our parenting plan. I do think it's necessary in this case to get a guardian ad litem. I ask the court, if our parenting plan is granted, to consider entering an order of child support, and I do ask the court to consider fees. I understand that a committed intimate relationship doesn't allow for fees, but again, my client was a pro se litigant for a vast majority of this litigation, and it should have been filed under 2 petitions: a petition for committed intimate and a petition for a parentage or parenting plan. And under our parenting plan analysis of RCW 2626B060, my client does have relief for attorney's fees, and we think that that's legitimate given the facts of this case. Thank you.
Thank you, Ms. Gilmore. All right, Ms. Winkles.
Yes, Your Honor, that's a lot to unpack. I'll start with the orders. So what we have here is we have a CR2A, and the reason we know that is because number 1, litigation had already started. This isn't your typical separation agreement. This is an agreement made contemplating litigation that's already ongoing. We can tell that these are final orders because number 1, they don't say anything about being temporary, but more important than that, they're all signed by a notary. They're all signed on the same day. They're signed back in March. We can clearly see the negotiations going on that Mom has entered with the court are on what is missing from this CR2A. It's not a complete CR2A. It's a CR2A on the distribution of assets, which nobody's arguing here. We all agree that that's done and dusted and done and has been settled. And what has also been settled is visitation. Child support has not been settled in this case. Neither is the final testimony been entered in the court. You can clearly see that they are still arguing about child support and about who's paying for what. And with regards to the parenting plan, what was entered was intended to be final. It is clearly confusing in the court record because it does say temporary. These parties, once the other attorney got out, you had essentially 2 people not really knowing what to do here and calling child support parenting plan, but the parenting plan was clearly meant to go with the other documents that were meant to be final. It would be strange. It would be a strange outcome if they signed 3 documents under penalty of perjury, if they signed 3 documents in front of a notary, and 2 of those were meant to be final, and 1 of them was not. And the one that was not never indicated on its face that it was not meant to be final, but the other 2 were meant to be final. That result doesn't make any sense. We believe that in this case, and there may be adequate cause, but we believe in this case, what we're dealing with here is a petition to change a parenting plan at this point because the CR2A, or to essentially vacate whatever. My client did file a response to that. The outcome of that would be roughly, we'd be in a very similar situation. However, we'd have to look at a change in circumstances. I won't argue that point unless Your Honor wants me to. I'll argue just the temporary plan at this point, I'll argue just if Your Honor believes there's been a change in circumstances, or Your Honor believes that there's been a temporary order and this is the result, I'll argue what they're alleging. We have to go back and look at what child.
Could I just interrupt? Might I interpose a question to both counsel? If I were to make a finding that the CR2A was to be, at least in the minds of the parties, a final order, does there need to be a motion filed for adequate cause, that there's been a change of circumstances for the court to make any changes to any parenting plans? Or is it kind of subsumed within the pleadings that there is an implied motion for adequate cause and modification? So I'll hear from the parties.
I mean, yeah, there is an assumption that moving forward without a cause, if that is the court's ruling. Ms. Weigel filed a response to a non-petition. So I think, yeah, for the intention of the parties, I guess at this point, we're either arguing adequate cause or we're arguing a modification based on the best interest of the child under a temporary parenting plan.
Thank you. Ms. Winkles?
Yes, so procedurally, there's three ways that you can bring adequate cause to the court. One is obviously the petitioner moves, the other one is the respondent moves, or the court itself moves. And in this case, as much as I'd like to, say that we could delay by me saying, well, neither the petitioner nor the respondent have done so. The fact is that we're arguing it really. So the court would have the ability to say we're arguing adequate cause, and Ms. Gilmore needs to do a motion. Probably she could do that motion after the hearing at the same time, because Your Honor would essentially say that we were doing a motion for adequate cause just based on what the parties are doing. But there has to be a motion in the record for it to be procedurally correct if that's the way we're going forward. And there has to be an order and adequate cause. You cannot change a parenting plan for anything that's major, which is what's being requested, without that motion and that order being in the record.
Could I ask a follow-up question? Ms. Gilmore alluded to that there's three ways that adequate cause can be brought forward. One would be the petitioner or the respondent file for a motion, or the court could do that. Can the court make a sua sponte motion for adequate cause and make a finding of adequate cause? Ms. Winkles?
Yeah, so based on what the parties are doing, I can't remember the word for the life of me right now. If the parties have argued, it's you can go back and almost change the pleading from, I can't remember the word, it's driving me crazy. Based on what we're arguing, Your Honor has the ability to motion, to essentially say we are motioning, but we need the underlying pleading. Because I've essentially argued it as well, I've waived the ability to object to if Your Honor says we're doing a motion for adequate cause, I would essentially have waived that by arguing this out anyway, if that makes sense.
It does. Yeah, I appreciate both parties' input. I think maybe it may be best just to streamline the argument for the court to make its decision related to whether it's a final order or a temporary order. Here, at least in my view, the agreement, well, there's arguments on both sides. The agreement to me and to my mind seemed to be a final order. And the reason I say that is that it was fairly comprehensive. The CR2A addressed a lot of issues, addressed the home, it addressed property, it addressed parenting plan, and it addressed assets and visitations. It did leave out child support. And then after that information was signed and then it was filed, basically it was left to sit for a year. So if I put myself in the shoes of the parties as they're negotiating and working through this, both being at this point, at some point thereafter, they were not represented. There's a sense there that they let it lie because they thought they were done. So I think that's fairly significant. When the attorney for Mr. Boehmer indicated that, hey, in response to the want of prosecution, hey, we're working on things, we're negotiating. That was a year after the documents had been signed. So that very well may have been child support, it may have been other issues, but at least in my estimation, there was the intent of the parties to have signed off on final orders through the manifestation of the CR2A and other documents that were filed. So related to adequate cause, I'll make a finding that there is adequate cause to modify the parenting plan. And that's based on certainly a change of circumstances. There's been some concerns related to the separation and how that's impacted the child, and how alcohol may play a role within that separation, and how that impacts the child. So I'll make that finding of adequate cause.
Okay. And then I would suggest, Your Honor, that Ms. Gilmore prepare that motion just so that the court record follows.
Okay, Ms. Gilmore, are you comfortable with that?
Sorry, for the cleanest version of the record, I will likely file a petition and motion for adequate cause, just to be the record, to be clear.
Okay. All right. Thank you. Appreciate that collaboration and help. So, Ms. Winkles, do you want to pick up from that point and continue, and then we'll get some time?
Yeah, absolutely. So we have to really look at what the child was suffering from before the parenting plan was signed. If you look at the mental health records and the records of the child, we see a child that already has some underlying mental health conditions. She's already anxious. She suffers from some essentially physiological changes from this anxiety. Doctors, if you read into what the doctors were saying during her visits, they were concerned that she was either hypochondriac or that she was having psychosomatic physical changes due to this anxiety or attention seeking. You can see that because she comes in for heart problems, stomach problems, head problems, hyperventilation, things of that nature. And the doctor notes, you know, she's tender, she's complaining of pain, but then she jumps off the table. She's complaining of being breathless and not being able to breathe, but then she's talking normally. So the doctors are concerned anyway that the child is essentially attention seeking. And this makes sense. This is a child that was essentially, I won't use the word spoiled, but maybe all the attention was focused on this child during this relationship. And then suddenly we have these parties separating. Child is no longer the number one. These parties are arguing. So they start, the attention becomes each other, really. And then the attention becomes this new partner. Child is receiving less attention. So child is attempting to create conflict in order to have the attention back on her. And we see that through a number of things. Number one, every time she's with a parent, she has conflict. You can see that in the mental health records. When she's with mom, she has conflict with mom. She's talking to the counselor about all these issues she's having with mother. Only when mother goes to the counseling appointment themselves does suddenly the child, you know, is great with mom, is working out with mom because mom is giving child attention. You see the same thing with dad. Dad is an alcoholic. Dad has all these issues. She doesn't want to go to dad's house until dad suddenly is essentially babying the child and giving the child as much attention, concern, you know, child has cramps, child goes to doctor. Child, you know, hurts or injures her thumb, child goes to the doctor. All of that, suddenly child is now back in dad's court. And so really catering to the child is probably not the best way forward, and both of them need to probably have the entire group needs to have some family counseling, that's for sure, in order to get on the same page about how to deal with a child that needs attention, and how to deal with a child, children in between, how to deal with a child when there's conflict and all of that. But really the crux of this is dad an alcoholic? Dad never said he had one DUI when he was young. He did have one when he was 19. He also mentioned that he had one in 2019. These are two different DUIs, obviously. They're 30 years apart or whatever. Dad made a mistake in 2019. Dad does have some poor coping strategies when things get tough. That might be drinking. Dad doesn't drink on a daily basis. Dad doesn't drink to get drunk. Dad goes long stretches, years without drinking. Dad has some poor stress related issues, and dad may have a drink when he gets stressed out. However, It doesn't even matter because dad has already entered treatment purely. And again, this is possibly catering to the child, but maybe the child needs this right now. Dad has entered treatment, not just 2 sessions of AA, but dad has gone to Ideal Options and gone to Cowlitz County Tribal Treatment. And the SUDS is included at CP 34. So I'm not really sure this evaluation was included at CP, should have been included at the top of CP 34, right in front of the child's counseling records. Dad went through and dad was very honest. And you can see everything about dad's drinking in there, including the DUI and everything like that. They didn't feel dad needed treatment. Dad is going to continue treatment though. And the reason he's going to do that is he wants to show the child that he is, he's willing to work on things, whatever she feels that there's a problem, he needs to work on. And so that's what he's trying to show her.
Can I ask you what his treatment is? Because they may said, no significant problem, no treatment recommended. So what is the treatment plan?
So the treatment plan, dad is actually he is doing NA. So he's doing NA, I believe, once or twice a week. On top of NA, or not NA, sorry, AA. I always get the two wrong. He's doing AA once or twice a week, and he's also going to Cowlitz Tribal Treatment for counseling. For, I guess, it's non-medicated treatment. It's counseling, peer therapy, things of that nature.
Once a week, twice a week, 2 hours shot.
And I don't actually know this because the SUDS came in so late. If I can just have my client, if Your Honor doesn't mind.
I would love to know that.
Mr. Bamer, how much are you going to that therapy at Cowlitz Tribal Treatment?
Twice a month. Yeah, twice a month, every other week.
Is it a group setting, individual setting?
Me and my fiance.
And then you meet with the counselor?
Yep.
Okay, thank you. Ms. Winkles?
Yeah, and then on top of that, he's doing AA as well. And he's also doing it with his girlfriend. And that is purely to have this a sober household. So that's the whole idea, is treatment doesn't hurt anyone. But my client states that a lot of this is just blown up. And you can see this in a fashion in what the child tells her counselor and what the child tells the doctor and what the child tells everybody. First, she says, dad doesn't drink around me. There's 2 instances where dad had a beer and upset her, just the one beer. So child is hyper focused on this issue. Dad has a beer, child gets really upset. Dad then stops drinking completely in the house. Child mentions that in her record. She said, dad doesn't drink at the house around me. And he doesn't drink there because he's not an alcoholic. He doesn't need alcohol to sustain himself. He doesn't have a dependence on it. He doesn't drink when she's there. She's still hyper focused on this issue. You also note that child says nobody believes he's an alcoholic. Mom and grandma, you got, something about mom and grandma are denying it and they don't believe it. And that's because mom didn't believe it until suddenly she needed something to grasp on. We also noticed that mom is really the one pushing this forward. So when they're at the doctor, it's not the child who's disclosing this to the doctor that she's upset and she's sick to her stomach because of dad's drinking. It's mom. Mom says to the doctor, I had to pick her up because dad was drunk. That's clearly mom inserting herself. And we see that time and time again here. This is not a change in the child's mental health. The self-harm, possibly. But really, this is prior to the relationship. When mom moved out with her new boyfriend, James Wagner, she made daughter hide this issue from dad. That caused the start of all of this. And child was really upset to have to hide this relationship, to move in with this new man, to be in a house with a third-party male that she doesn't know. That was a lot on a 12-year-old little girl. She started having stomach issues, missing a lot of school and the like. This anxiety and this hyper focus on dad is new. And that happened after dad said to his child, which he possibly shouldn't have. And again, some parenting classes are definitely in order here. He told his daughter that he was going to marry his new girlfriend. Dad is a middle-aged man, doesn't understand that might affect a 12 or 13-year-old little girl. Maybe if, and not sexist in any way here, but quite possibly you could tell a male child that and it would be absolutely nothing. But to tell a little girl that was probably dad's not a shining moment, in any event.
So in this case, the new boyfriend is a case or making things difficult for dad. He is literally coursing drama in family. It is all because the mom allowed it to happen.
My client's life more difficult. The reason he showed her the UAs that he took is because child demanded to see the UA or refused to come to his house. So my client did it. And showed her the same reason he's going to treatment. He wants to show her that he's willing to make this extra effort, that he's willing to work with her, and he wants her to feel safe in his house. Now, concerning the allegations of domestic violence, we have the woman who is supposedly the victim here saying this never happened. We have a chaotic scene where the children are all showering. It's flooding the floor because these are little girls. They're flooding the floor. Somebody runs out and tells dad the pipes broke. Dad runs in, kind of moves everybody out of the way. And then they start moving furniture, and I'm sure everybody was screaming. And I'm sure, when things like that happen, I'm sure people were, maybe even bickering, maybe bantering, maybe saying, what the hell, get the hell out of my way, things of that nature. But again, this child is hypersensitive and hyper focused on anything that makes her uncomfortable goes from a 0 to a 10. So she calls the police. The police come, don't make any arrests. Nothing happens. There's no injury. There's nothing. My client then essentially just tries to work with the child here. Child's hyper focused now that everybody doesn't like her. And that's not the case. This is a child that is very, very sensitive, that needs a lot of extra care and probably needs agreement, guardian ad litem here, to help these parties deal with this hypersensitive child, to not feed into it, but at the same time to respect that it's there. But there is no domestic violence. This is not a man with a history of domestic violence. This is not, do they argue? Yes. Do they bicker? Most likely. But this is not a man that has any of those issues. With regards to the hair follicle, a hair follicle exam with an ETG goes back 90 days. It will pick up, because it's hair, it will pick up any sort of product you put in your hair that has any ethanol in it, which is pretty much 90% of cheap hair products. If you use really nice hair products, probably not. But the fact is, his was 0.23, 0.20 is a cutoff, which means he had just a tiny smidge that would show up on a hair follicle exam. That could have been from anything. It could have been from a beer that he had absolutely, 3 months ago. But what is really interesting is that alcoholics, unlike other drug addicts and other addicts, can't stop use. And that is, they have the highest recidivism rate of pretty much any substance abuse. It can't stop and stop for periods of time and then suddenly start again. That's binge drinking. It's a whole other type of addiction. But dad's UAs, which look back 72 hours, are both clean. We have 2 UAs taken like 2 weeks apart. They're both clean. That shows almost a 2-week window of not having any alcohol. If dad is actually an alcoholic, that is one of the most amazing things that dad can do that, because most alcoholics can't do that. They require medical detox with benzos usually. If they're not that bad, they require lots of outpatient care to even be able to get to 2 weeks without alcohol. If we look at the SUDS again, dad's very clear. Changing the mental health facility, her doctor quit or essentially moved up in the practice. There's child wanted care. Dad made sure to get care. With regards to the demanding the records, that's in the medical records themselves, in the mental health records, it clearly states that dad asked her, child went, doctor said, and this is all in those records, doctor said to child, are you sure you want to do this? This is what they're going to use them for. Child said, I'll think about it. 2 weeks later, child said, yeah, I want them to have that. This makes sense. The child wants them to have it. Everything child's done is attention seeking. The self-harm is attention seeking in its own way. The hypochondria, the calling the police, everything that child's done is to get focus on her. Everything, and that is included in this. It's that she wants the court, she wants everybody to know how she's suffering, she wants this attention, she wants the parties to focus on her. This is not a case where dad should not have visitation. This is not a case for supervision. This is a case for all parties here, mom and dad. They've equally done things, getting with new partners, involving the child in it, that are wrong for a sensitive child. They should both be they should all be in counseling together. Whether or not they hate it, they need to suck it up. They should both take children in between because they're not doing it right. And they should be working with the counselor together as a united front. This is a case where these people need to get over themselves and start working together, but it's not a case for any sort of suspending of visitations or changing that. Regard to the kill yourself comment. My client is a normal man, a normal guy. The child was refusing to come out of her room. My client said, well, if you're going to stay, they were watching a movie, if you're going to stay in the room for the rest of your life, you might as well kill yourself. Not kind of a crass comment. Had he realized that this child was suffering as much as she is, he wouldn't have stated it. He thought it was funny. Child didn't take it like that. He'll never make the comment again or anything like that. He now knows how much it upset her. He's just a normal guy trying to understand a child that's very different from the rest of these people. But both of these parties have caused this. They fed into it, but mom with her secret relationship and her leaving the marriage for her son's friend, dad for getting with a woman that he's going to marry when he didn't marry mom. This is a lot for a little girl to handle. Finally, attorney fees, and I've talked way too long and I apologize. CIRs are very specific in that they do not allow any form of attorney fees. They don't allow it. And this case is not filed as a separate parenting plan. It's filed as a CIR with the parenting plan included, and that is acceptable under a CIR. So while it might be easier to do it the other way, it hasn't been filed in that way. Additionally, mom doesn't have a need. Mom makes good money. Dad doesn't have the ability to pay, and he's paying for himself, and it's going to be most likely expensive. We'd ask for no attorney fees. I think we're here when the parties should have been trying to work on this. A guardian ad litem is probably not a bad idea, though. Not even for the investigation, just to get these people some resources. The child's not going to get any better unless they start working together.
Thank you, Ms. Winkles. Ms. Gilmore.
Yeah, I do apologize. I somehow missed this substance abuse evaluation. It does look like it was filed on the 3rd, which I believe is Friday. Did have the opportunity while counsel was making arguments to just briefly glance over, and I do have some concerns. Father, frankly, doesn't report anything to the provider. I don't see anywhere where he disclosed his numerous DUIs as recent as 2020. He actually, on page 2, under dimension 5, reports that he has gone a year without using alcohol, which directly contradicts his own statements in his declaration. That's what I see here a lot of contradictory statements to excuse or explain away bad behavior of father. And again, I think that he really at this point is willing to, again, throw this child under the bus and say that she's overly sensitive. But I don't think that the mental health records really suggest that she's not disclosing anything that's what she believes to be inappropriate. And I think that, frankly, it is inappropriate. It is inappropriate to tell a 13-year-old child to kill herself. And I think that the crux of that is the father alleges that he's in support of the child's mental health. He's spearheaded getting her to treatment, but then admits to making these type of statements. Again, all of this information just simply contradicts itself. And again, I would just like to highlight, he now admits to having a DUI, multiple DUIs, but I'm looking to page 3 of his declaration midway through. He suggests, in 1997, I was arrested for both minor possession as well as a DUI. I was 17, 18 years old when this event occurred. I'm now 46. I mean, these are all suggestions that he doesn't have an issue, he's willing to make excuses, and the child is frankly continuing to have ongoing issues because of the back and forth yo-yo of father prioritizing alcohol beyond his visitation and relationship with his child. So I do ask the court grant our motion.
All right, thank you. All right, I appreciate the parties' emphasis of your different points and the argument presented. Having made that finding of adequate cause, I just want to talk a little bit about the child. I found interesting one of the doctor's entries indicated that this, I think they described it as a complex presentation. And I think that's a fairly accurate portrayal. Like I said before earlier in the docket, humans are complex, especially when children are young, they're growing, they're developing, they are encountering a huge life change, that their parents are no longer together. There's involvement of the children in adult issues. There's new companions, new partners. Terribly difficult and hard for a child to navigate all of that when they themselves are trying to get their feet underneath them, and the carpet's kind of been pulled out from underneath them. So there's some real challenges there for the young lady that she's working through. Could it be attention seeking? Yeah, it could be. Could it be other things? Yeah, it could be a whole host of issues. And gratefully that there's medical professionals and others that are giving their best efforts to address those issues.
Today's credit goes to our court watchers. Don't to subscribe to my channel AI Reaction. Let's dive in.
I'll just touch briefly, the change of the mental health provider. It sounds like there's some rationale for doing that. And I think anytime that there's been a separation between parents, the actions of another are always met with skepticism and suspicion. What I think is important is that the child is continuing to receive care, so that's great, and I appreciate the parents doing that and making her a priority. The issue related to the alcohol and Mr. Boehmer's consumption of the same. So I think that the records are fairly clear that he's had 3 DUI convictions. 2 are much earlier in his life, and 1 occurred in 2019, and I think the conviction occurred in 2020. So what that suggests to me, and then I take this into, I looked at the evaluation, indicated that generally takes about 2 to 6 hours a week of drinking activity. That doesn't necessarily mean that you're taking one beer or one drink after another for 2 hours, but it's sitting in a social setting or otherwise consuming alcohol anywhere between 2 to 6 hours. I think that's interesting. And the overall sense I got from the evaluation, the evaluator indicated, that there was, I think the phrasing was possibly downplaying issues. I think as a human being, it is very difficult to self-assess and have a very clear picture of what we are, what we're doing, how we present, and what we're doing in life. And our normal reaction to being confronted with something that's maybe not right in our life is to minimize, is to downplay. That's my sense. That's what's happening here, is that Mr. Boehmer has been able to function well during his life and continue to drink alcohol. And sounds like he has no plans to quit drinking alcohol. There was some suggestion that naltrexone, which my understanding is it's a drug that you take, and if you consume with alcohol, it makes you pretty darn sick, and it's definitely an aversive medication. Whether Mr. Boehmer is willing to do that's really not my call to make at this point. If he's interested in showing that alcohol takes a backseat to his child, that might be a consideration, but I'm not making any rulings related to that. So I think that combined with this separation between the parties, Mr. Boehmer was pretty forthright and indicated, yeah, I started drinking maybe more heavily than I had in the past. And I get that. And what that suggests to me is that there's some coping skills that maybe have not been fully developed, that the alcohol has served as a crutch for a long time. And when the going gets tough, rather than using different coping skills, alcohol is turned to as a coping skill, which generally is not a good long-term effective coping tool. It may be feel good in the moment, but overall it doesn't necessarily lead to addressing underlying issues that every single human has, and that we all do our best to try to cover up through different ways of coping. So I think I think that a SUD evaluation, a new one, needs to occur with collateral input from Ms. Kelly and also the guardian ad litem that I will be appointing. So I think that's important to look at that more closely. As far as the guardian ad litem, I will appoint a guardian ad litem. It'll be private pay. And I'll ask if we can just address that now by having the clerk share the 3 next individuals on the list, and then each party can strike if they'd like.
Ann Height, Twyla Corey, Keith Lawrence.
Okay, so in order, we have Ann Height, Twyla Corey, and Keith Lawrence. Moving party is Ms. Gilmore.
We already did. I'm fine with Anne. We already discussed that. Ms. Winkles, are you fine with her?
Yeah, I was gonna strike Keith Lawrence, so yeah, Ann Hyde's fine.
Okay, Ann Height is hereby appointed as guardian ad litem. Her job obviously will be includes addressing issues of alcohol consumption and impact on parenting, father's relationship with his partner, mother's relationship with her partner, the daughter's mental health and well-being, and how best to support her. I think it goes without saying the counseling for the daughter will continue, and that both parents should and are required to complete developmentally appropriate class for children, for parents, pardon me, for children who are undergoing a divorce or separation. I think that would be really important.
Hello, guys. Welcome to another epic family court case.
Both parties focused on the comment made by the father related to his daughter not coming out of the room. And I thought it was interesting that Mr. Boehmer included in his declaration, he said, "I was making a joke to my child like I'd made 1,000 times in the past," which, when I pause for a second, actually hurts my heart quite a bit. Children are exceptionally sensitive to anything that their parents say. And I don't know if Mr. Boehmer needs to hear this or not. Maybe he doesn't. But when a parent tells a child to go kill yourself, that is a clear, direct statement to your child that you do not matter as a human being. And if you cease to exist in this life, no big deal. It's terribly damaging. And if it's occurred on a repeated basis, that has to stop. That has to absolutely stop. And hopefully it has, and hopefully it'll never repeat itself. And hopefully that those comments were made during a time when there was maybe intoxication or what have you, or maybe the inhibitions were down. But that has to stop. Words are absolutely powerful. Children take them to heart, and they permeate, and they stay at the cellular level, and they manifest themselves in decades later. That has to stop.
Today's credit goes to our court watchers. Don't subscribe to my channel.
I understand.
Let's dive in. Hello, guys. Welcome.
And my client is enrolled in parenting classes, a couple of them already. So we're trying to deal with those things.
Okay. The next kind of the elephant in the room related to the parenting plan and the parenting time, residential time. This is my sense. A lot has changed for this young lady. A tremendous amount of upheaval and change has occurred and is occurring all about her. If I were to change the parenting arrangement, I'm concerned that would cause further disruption and may not be in her best interest. So what I'm going to do at this time is keep the parenting plan, the status quo that the parents had been involved in, which is the 50-50. The guardian ad litem will be appointed. Guardian ad litem will issue a report, and we'll take a fresh look at things based on that report to see if there does need to be some type of change. But at this point, I'm going to leave that as is. The parenting decision-making will continue to remain joint. The alcohol testing provision remains in place. I'm sensitive to the hair follicle test because it does go back. My sense is that what the court's more looking at is if there's drinking during residential time. So in other words, when the father has the child during his residential time, when it's his residential time, there can be zero consumption of alcohol. And what becomes a little bit tricky with this is that at the end of his time, let's say it comes to the end of the week, it's Friday, and Friday morning he drinks a beer, and then the mother requests, maybe it's at 4 o'clock, and then that's after the exchange has taken place. there's an alcohol test. So what that probably does is limits Mr. Bamer's alcohol consumption to probably the next week, Tuesday and Wednesday, and that's probably about the only time he's going to be able to drink. So it's going to significantly curtail his any consumption. So the mother can request an alcohol test. It has to be taken within 4 hours at any time during his residential time, and the day before the visitation, and up to 24 hours after a visitation. That request can be made. And so that puts really tight constraints on Mr. Bamer. I want him to understand that this is the court is taking this seriously. It may not be an issue, but I'm erring on the side of caution. But that provision will be in place. Related to the parties didn't address child support at this point. So I think I'm going to hold off on that because it is a 50-50 at this point. That may certainly change in the future if there's a showing that there's a need for one parent or the other. As far as the attorney fees, I'm going to hold off on that. I'm going to reserve on that issue at this point in time. We're here fairly early. It can be raised at a later time. I believe that addressed the issues that the parties presented to the court. I may have missed something, or the parties may need additional clarification. So I'm open to hearing from each of you.
Actually, before the court on a presentation of the order as well. I know counsel presented objections. I do not have them in front of me right this second. I guess I would just defer to the court on whatever changes you would make. Did you receive a bench copy of that? Is that before you?
No, I don't have that.
Maybe we can address at the next presentation all orders. Is that fine with you both?
Yeah, that works for me. We can address
Okay.
because I didn't think it changed anything. It's just to clear up the record.
Yeah, okay. And then my last question is percentages on for the GAL with a private pay. There is a disparity of incomes, and I both of us presented worksheets.
Yeah, let's address the presentation date first, and then we'll talk about the percentages. Presentation date. Would the parties be available on the 21st of November?
Hello guys, welcome to another epic family court case filled with
Yes.
drama, heartbreak, and more.
I have a trial, but I always have a trial. So they go or they don't go. So I'm just booking things. So
okay. Well, let's set up for the 21st of November at 9 a.m. for presentation of all orders. Regarding the percentages, this is what I found. As far as the mother, I found her net at 38, her gross at 38.61, her net at 32.34. For the father, I found his gross to be 66.60, and I wasn't exactly sure on the net with the deductions. I kind of gave it a thumbnail view and set it at 5,800. So we'll use the 5,800 as the net for father, 32.34 for the mother, and this is for purposes only of guardian ad litem's division of fees.
okay.
Additional items, either Ms. Gilmore or Ms. Winkles.
Your Honor, you said parenting classes were important. We're ordering those though for both parties, correct?
Required, correct. And I was this close to requiring both parties to undergo counseling, because my experience has been, and it may be off, is that when a child is suffering deeply or having a lot of difficulty, the parents being in counseling also can certainly help a lot. And it sounds like Mr. Bamer is doing that, but so I'm not going to require that, but the class I am.
Okay, sounds good. I have no more questions.
All right. If there's nothing further, that'll conclude the case and for today, and we'll see everybody on the 21st of November at 9 a.m. for presentation.
All right, thank you, Your Honor.